This is our second video lecture about Model Rule 1.15 or 1.15 about safekeeping client property and funds. And in the first video, we talked about the big idea that you can't commingle funds and some of the specific rules about maintaining separate client trust accounts for client funds. In this video, we're going to be talking about the provisions about what to do when there's some disagreement about the funds that you're holding on to and who has a claim to them. So having said that, let's take a look at the remainder of our rule. Okay, this is 1.15D, and I've subtitled this Prompt Notification and Delivery. Upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. And so watch out for test questions on the MPRE about a lawyer who leaves the money sitting in the account for a few weeks while they go on vacation or something like that. What do we mean by promptly? As soon as possible. It's hard. You're going to have to justify waiting more than a business day or two to notify the party that the funds are for that they have come in. If you have to wait for a check to clear when you put it in the account before you can cut a disbursement check or remit the amount to whoever it goes to, that's okay, but you should notify them as immediately as you can. D continues, except as stated in this rule or otherwise permitted by law or agreement with the client, a lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and upon request by the client or third person shall promptly render a full accounting regarding such property. So two things. Not only do you have to notify the person right away, you don't get to hold on to funds. And if you try to keep funds in your client trust account for a long time, we start to get suspicious that maybe you're giving yourself a loan or using that money to cover some of your operating expenses, hoping like floating yourself a loan from your client's funds, and that's strictly forbidden. And so we expect you to notify whoever the money is supposed to go to, the client or third party, and then disperse it as soon as you can, as soon as the bank that is holding the account will release the funds. And if someone asks for an accounting because they feel uneasy about it, you have an ethical duty to provide the accounting for this. None of this, like, that's none of your business or that's confidential. If the party was owed money, they are also owed an accounting about the money. E, when in the course of representation, a lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claim interests, the property shall be kept separate by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. So here's our first scenario I want to give you. You call your client, you say, hey, good news, the other side sent the check, we won $100,000 or something like that. So I'm going to be sending you your amount and I'm going to keep the $30,000 or $40,000 for my contingent fee. And plus I'm going to keep $10,000 or $20,000 for the costs and expenses of the litigation like we agreed on. And then the client says, oh no, you don't. You know, either I don't think you earned that much, I didn't agree to pay you that much, or I think you're responsible for the costs and expenses. Well, now you have a dispute, right? So what we're going to do is figure out how much do you disagree on, and you're going to keep that in the client trust account until you resolve the dispute. If there's any amount that you both agree that the client is due, you cut a check for that amount immediately. And if the client says, look, I don't think you deserve more than $20,000, you pay yourself $20,000 and you're going to worry about the rest later on after you solve this with the client. But so if the client agrees that you are at least owed a certain amount, withdraw that from the client trust account right away and only hold the remainder that is still in this dispute. This is also true when there's a third party that calls you and says, some of that money is mine. Okay, comment 3 to Rule 1.15. Lawyers often receive funds from which the lawyer's fee will be paid. The lawyer is not required to remit to the client funds that the lawyer reasonably believes represent the fees owed. However, a lawyer may not hold funds to coerce a client into accepting the lawyer's contention. Please pay attention to this comment. This specific point is tested pretty frequently on the MPRE. I predict that at least one of your questions about this rule will be about a lawyer who is refusing to disperse any of the client funds until the client agrees to the lawyer's fees, what the lawyer's fees and costs and so forth should be. They're going to ask you about that, and you don't get to hold up the amount that you both know belongs to the client in order to get the client to settle a disagreement with you. The disputed portion of the funds must be kept in a trust account, and the lawyer should suggest the means for prompt resolution of the dispute, such as arbitration. And the undisputed portion of the funds must be promptly distributed. E also recognizes that third parties may have lawful claims against specific funds or other property in a lawyer's custody, such as a client's creditor who has a lien on funds recovered in a personal injury action. Here's a scenario. Your client, you've been representing your client in a personal injury action. They're a plaintiff, and they've recovered a verdict, an award. And so you get the money in. The opposing party's insurance company has sent the check, and let's say they're settling the case. Well, the problem is the client, let's say, owes a lot of medical bills and has a whole bunch of unpaid medical bills, and their doctor or the hospital, that whoever they owe the bills to, has already turned it over to a collection agency, and they've already obtained a judgment, let's say, a court order against the client that they get to execute on the funds, hypothetically. It's more common than you would think. Well, maybe the opposing party or insurer has already notified the healthcare provider that they have cut a check. So they know that you have the money. They call you saying, don't give that money to the client. That money it belongs to us. We're owed $50,000 or $100,000 in unpaid medical bills, and now you have a problem. And of course, if you ask the client, they're going to say, no, give me the money. I already bought my tickets to Vegas or something like that. And now you have a problem, because if it's plausible that the other party has a claim to the funds, you don't get to just disperse it. And you may have a duty under applicable law to protect such third-party claims against wrongful interference by the client. In such cases, when the third-party claim is not frivolous under applicable law. So we're not just talking about somebody calling and saying, you know what, I really feel like your client should give me some money. That's different than somebody coming who, the client has unpaid bills, medical bills or something. If it's plausible, you must refuse to surrender the property to the client until the claims are resolved. Wow, is your client going to be mad at you? A lawyer should not unilaterally assume to arbitrate a dispute between the client and the third party. Please note that. That may be your first instinct to say, I'll tell you what, why don't you both come in and we'll work this out, and I'll mediate between you. Don't do that. When there are substantial grounds for the dispute as to the person entitled to the funds, the lawyer may file an action to have a court resolve the dispute. That is the right answer if you get asked about this on the MPRE. If a third party, like a creditor, the healthcare provider, notifies you that they are entitled to part of the award, don't give it to the client, you're going to ask a court to solve the question. Okay, a couple quick words about money and why we sometimes call these IOLTA accounts. You're going to hear lawyers, and sometimes even your state bar is going to refer to these as IOLTA accounts. I saw a recent disciplinary action where they referred to it in the published decision as an IOLTA account. So we have these two sources of funds for legal aid clinics. And this, by the way, this applies to law school clinics. Some of my students may have done a clinic while you were in law school. The funds don't just come from the school. So a long time ago, back in the early 1970s, Congress created something called the Legal Services Corporation, or the LSC. This is a from a standpoint of nonprofit law, this is a 501c quasi-governmental corporation. They receive a budget allocation every year from Congress. In a really good year, it's like $350–450 million. And just the LSC has a board, and they disperse funds through grants to legal aid clinics and law school clinics. And so clinics, legal aid offices and law school clinics all around the country can write to the Legal Services Corporation asking for grants. And the same may be true, for example, if there's a courthouse that wants to run like a Saturday morning pro bono clinic or something like that, they may ask for funds from the LSC for this. Now, in the late 1990s, there was a period when the Republican Party took control of both houses of Congress and enacted sweeping legislative reforms. They overhauled our welfare system. They we had sweeping immigration law, habeas law, all sorts of things were changed in 1996, 1997. And they also targeted the Legal Services Corporation because they felt that the belief was that legal aid clinics tend to be left-leaning and progressive and to represent criminals and immigrants and to advocate for civil rights and things like that. So what they did was they amended their charter to have a whole bunch of, a long list of things that they're not allowed, funds cannot be used for. And if you do those things, you can't receive funds. And this included representing criminal defendants, anything that's immigration advocacy or representing immigrants in their immigration cases, divorces and child custody, advocating for abortion rights, or bringing any type of personal injury lawsuit or class action. And so it significantly narrowed what law clinics are allowed to do if they get LSC funding, and most of them were, to be honest. They get some funding from private donors and the legal community, but a lot of them were dependent on grants from the LSC. So the response was to this sudden curtailment of funds, something called IOLTA, which stands for Interest on Lawyers' Trust Accounts. So IOLTA is an acronym for Interest on Lawyers' Trust Accounts. So historically, client trust accounts do not actually pay interest. The banks, just they're non-interest bearing business accounts. And so the state set up these programs where if a lawyer opens a client trust account at a bank, if the banks participate in IOLTA, they will skim off the interest that the account that would normally accrue from a client trust account and turn it over to the state bar. And the bar then has a grant program and makes grants to law clinics, to legal aid clinics and law school clinics and so forth. In Texas, the IOLTA money first goes to the Texas Access to Justice Foundation, and then they disperse it through grants that law school clinics and legal aid clinics apply for. And so the benefit of this was that that it comes without the same types of restrictions as LSC funds. And in fact, some legal aid clinics partitioned their services to have one office that's funded by LSC that does LSC permissible activities, and another clinic that does the other stuff that's forbidden by LSC that is funded by IOLTA and so forth. Now, just to make sure that you understand the concept, and this will be relevant for your life because some states require lawyers to have their client trust account be at a bank that participates in IOLTA. Others, it's optional. And so you're going to have to check the rules in your state. Think about it. Think about that you do a residential real estate closing for your client. The average residential home in Texas is $200,000, let's say. And so whether you're buying or selling, at some point $200,000 passes through the lawyer's hands, and you're going to park it in your client trust account for a couple days, and as soon as the money clears and can be dispersed, you're supposed to disperse it under Model Rule 1.15. So how much interest did that $200,000 accrue in one day? A few cents, right? Really, really not much, and not enough to be worth like accruing it and adding it to the amount that goes to the client or the party that the money belongs to. And the lawyer shouldn't keep it either. So remember, under the rules about client trust accounts, we couldn't have, it made sense that there was no interest being paid, because the interest, it would have been unclear, is the interest the client's money, is the interest the lawyer's money? And if it's a lawyer's money, it can't be in the account and so forth. So they just didn't pay. So now in the aggregate, on any given day, there's tens of millions or hundreds of millions of dollars sitting in all of the client trust accounts across the state. And that interest does add up, even if it's a few cents on each client's deposit. It adds up. And in a good year in Texas, we've had as high as like $15 million over the course of the year that then goes to IOLTA. Now, the last thing you need to know about this, just in case they ask about it on the MPRE, is this was challenged, this scheme was challenged as an unconstitutional taking back in the late 90s by the Washington Legal Foundation, which is sort of a conservative mirror image of the ACLU. And so they went to the US Supreme Court. It was a divided decision, and the court held that it was a taking, that interest income generated by the funds held in IOLTA accounts was private property of the owner of the principal, that is the client, for purposes of the takings clause. And they found a client who was upset that the 50 cents or 10 cents or something that on their trust account money was being used for liberal or progressive causes that they didn't believe in. The court remanded it to calculate the amount that was due under the taking, and it goes back up to the Supreme Court in 2003. And we had some changes on the court, or a swing voter changed their vote. So this time they said, okay, even though it's a taking, the zero interest was owed. So it's technically a taking, but it doesn't matter because the compensation is zero. So as you can imagine, between 1998 and 2003, there was a lot of concern in the legal aid community that IOLTA was going to go away and be held unconstitutional. But the Supreme Court has held that this is okay, that even though it's a taking that doesn't require compensation. And so there's no real legal basis for a challenge here. That concludes our lectures on Model Rule 1.15.